for a pretrial conference. Ms. Fan, how are we proceeding?
Your Honor, we would like to proceed by requesting a final pretrial conference and discovery with a not guilty plea.
Court is going to continue a not guilty plea on behalf of Ms. Allen. Set the matter for final pretrial conference, July 13th at 9:00 a.m. Discovery should be submitted to the defense by June the 13th. Bond will continue. And what's the current contact provision? What is the nature of the relationship with the children?
Your Honor, she has the children back. This case is from 2019, 2020. She was detained for another complaint, and this matter was just brought forward. She wasn't sure why it had not been brought up when the children were not in her custody. However, she has been back and has had them back since 2020.
Ms. Ritter, how old are your witnesses?
So back in 2019, Your Honor, they were 12 and 10. So 14 and 16, around 14 and 16 now.
What did the magistrate say at the arraignment with respect to contact?
So Your Honor, I was trying to look up the ROA, but it looks like the 36th district site is down for maintenance, so I'm not sure.
Mr. Flanagan, can you tell me what the bond conditions are?
That's right. Hold on. Let me see. Just no contact, and it states the victims' names.
So let me say something. I want to be clear about what I say. So in essence, Ms. Allen has been in violation of the court's bond conditions since the date of her arraignment with the magistrate. It would have been appropriate at that time for someone to bring to the attention of the magistrate that she had custody of the children and allow the magistrate to determine whether they were still going to allow her to have contact with the children. When the court gives an order, it is the court's order. It is the court's order, and it is to be followed to the letter and to the T. So Ms. Allen has currently been in violation of the magistrate's bond condition by retaining custody, care, custody, and control of these children when the magistrate said no contact.
Judge, I would just like to say that the state gave her children.
Ms. Van, I could care less. You was about to make me say something wrong. I don't care who in charge of the court. I don't care nothing about what the state said. I'm talking about from the date of her arraignment, when the magistrate, who does not answer nor respond, nor have any requirement to consult the state, when the magistrate said that Ms. Allen was to have no contact with her children, then it was the responsibility of whatever lawyer was representing Ms. Allen, if they didn't do so, because they may have done so, and the magistrate still could have said no contact with the complaining witnesses. So let me be clear about this. Whatever my order is, I don't care what the state says. I don't care what CPS says. I don't care what anybody else says except a court that is higher than me. So when the court gives an order, unless an appeals court overturns that order, Ms. Allen, you are going to follow that order, or it is not going to work out for you. I am going to amend the no contact provision, despite the fact that since the date of her arraignment, Ms. Allen has been in violation of her bond conditions. I am going to amend the no contact provision to a no assaultive contact. I want Ms. Ritter to contact her witnesses and find out if they have a problem with that amendment. The second part of my order is that if I find out that Ms. Allen has in any way, shape, or form discussed this matter, these charges, and the incident with those complaining witnesses, I am going to revoke that bond. I am going to change that condition, and the children are going to be removed from their home until this case is resolved. Ms. Allen is to have no conversation whatsoever with the two complaining witnesses regarding these charges. Please understand, again, Child Protective Services has no bearing on these proceedings. This is not a family court proceeding. This is a criminal court proceeding. Everything I say is what goes. There's no one that can override me unless this decision is appealed to the Wayne County Third Circuit Court. I hope that I am making myself clear. Ms. Ritter, do you have the contact information for your complaining witness?
Judge, I don't have a phone number for the complaining witnesses.
Well,
So
you may need to send your OIC out to the home.
okay,
Anything
Thank you
further?
for that amendment. No, Your Honor.
not for the people, Judge. Thank you.
All right, then we are all set until July the 13th at 9:00 a.m. Have a great day and stay safe. Your client continues, despite this being the 4th time that I've lowered her hand, she continues to raise her hand. I will send her to a breakout room so that she can speak to you personally, since I don't know why she kept raising her hand when I kept lowering her hand. I don't understand that. Okay, so she
I'll
was
meet her in the
in
breakout room after
breakout
argument.
room
Thank you.
number. I don't see that.